I'm Vinnie Politan. The subject of my investigation is the death of Boston police officer John O'Keefe and the dramatic retrial of his girlfriend Karen Reed. It's a case where the public has strong opinions, with each side seeing the evidence in only one way. And now a new jury must see if they can agree on what happened to John O'Keefe. Here's the story. The death of John O'Keefe, found lying in the snow outside of 34 Fairview Road, has been shrouded in controversy, particularly surrounding the mysterious wounds on his arm. Some argue the injuries were consistent with a violent attack by a dog. However, the prosecution claims these wounds were inflicted as part of a violent confrontation between O'Keefe and his girlfriend Karen Reed. They contend the injuries result from a deadly collision when Reed struck John with her SUV and then drove away. All of this happened right in front of 34 Fairview Road, where an after party was underway. But no one at the party or anyone who came by the house that night saw the deadly collision. In addition, no one saw John O'Keefe's body on the front lawn. Prosecutors say that's because no one was looking for a body, but the defense says that's because there was no body left on the yard until someone placed him there hours later. Now the jury in the retrial has to figure out when and how John O'Keefe ended up dead on the front yard. Juries like eyewitness testimony. They do. Many times they find it very, very compelling. You know, if you go back in time with the Innocence Project, and a lot of the cases that were overturned with DNA years later were based upon convictions from eyewitness testimony. So it tells two stories, right? Eyewitness testimony is compelling. It's direct evidence if it's evidence of the crime itself, but it's very compelling for a jury, but sometimes it's not necessarily reliable. But I don't think juries look at it that way. I think juries listen to witnesses and they tend to believe what they say they saw or what they didn't see. And in this case, no one saw John O'Keefe get struck by an SUV. No one saw the SUV go in reverse, and no one saw the SUV drive away after John O'Keefe was allegedly hit. And no one saw John O'Keefe on the front yard. So there's a lot of seeing nothing, but how important is the fact that no one saw anything in this case? Does that equal reasonable doubt? That's a big picture question in the trial of Karen Reed. Now let's get to some testimony. This is Lucky, the snowplow driver, who that night there's a nor'easter coming in. He's on duty. This is part of his route, Fairview Road in Canton, Massachusetts. So take a listen to his testimony about what he didn't see and what he did see.
What was on the ground on the Alberts lawn at that point in the area of the flagpole?
Nothing.
Did you see a 6'1", 216-pound man lying on that lawn?
No.
How much of the front lawn of 34 Fairview could you see?
I could see all the way to the front door.
What obstructions were there at the time when you first passed the Alberts residence?
None.
Were you familiar with the area of the flagpole on the left side of the property?
Yes.
Now, when you are plowing, sir, where is your attention focused?
My attention's focused out the front window, to the right and to the left.
Why?
I am looking for pedestrians. I'm looking for residents that may be backing out, not aware that I'm there, and God forbid, animals. As I make my right onto Fairview, I notice that there's a vehicle on the right-hand side roughly in the area of the flagpole in front of 34 Fairview.
Okay. And did you make note of what type of vehicle that was?
Yes.
What type of vehicle was that?
A Ford Edge.
Both pieces of this testimony extremely significant for the defense as they attempt to demonstrate to this jury that there is reasonable doubt, that there's perhaps something else that is going on here. One, he doesn't see John O'Keefe's body, right? And then two, later that morning, he sees a Ford Edge or some sort of vehicle parked near that flagpole in front of the house. And that kind of is out there now as part of this case. But all of this brings us to the first question in our investigation, and it's about Lucky. Should the jury trust Lucky's memory? Now, I don't know if anyone's going to think that he's lying or making things up or if he's misremembering. I don't know. But the most important part of this for the jury is, should they trust it? Let's bring in our guest to help us answer this question. Massachusetts trial attorney, but you recognize him from the Johnny Depp trial. Wayne Dennison is with us. And also with us, John DePietro, host and creator of Road Patrol Live, who's been in the courtroom for this trial. Great to have you both here. Let me start with you, Wayne. Should the jury trust Lucky's memory here?
I think the jury should trust Lucky's memory, but the problem is what he's testifying to is the lack of something. And the notion that he didn't see something is suggestive of the fact, certainly, that there was nothing there, but of course he could have simply missed it.
But there's the other part of it. Later on, he sees a Ford Edge or some sort of SUV parked on Fairview right near the flagpole. How about that part? Should they trust that part of his testimony? His memory?
I think you're gonna trust that part of his testimony. He's trying to run a snowplow, and now he's got a car in the way. I think he's going to be pretty clear cut on that one.
All right, John DePietro, there was obviously cross-examination of Lucky by the special prosecutor. Let's take a listen to a piece of it.
You're saying as you sit here today, you have no awareness in the history of this case that you were being threatened by an online blogger.
I was not threatened by an online blogger.
Was the person communicating and making clear to you that if you didn't testify in a certain way, there would be some consequence to you?
Do you know if he is friendly or supports one side over the other?
I know he is friendly towards one side, yes.
Okay. The side sitting in the back of the room?
I would say to the fencing.
This is a fascinating moment, John, because the name isn't mentioned, but we all know who he's talking about. And he was in court that day at Turtle Boy. There he is,
Yes.
Aiden Kearney, in court, is a member of the media, gets the pass, gets to go inside. There's a limited number each week that are going in there. Turtle Boy did speak after court about this alleged threat. Here's what he said.
So I messaged Lucky, I introduced myself, and he said he didn't want to talk. So,
did you threaten him?
Absolutely not.
Say he's revealed things about him?
Absolutely not. I posted the entirety of our messages with receipts on my Twitter account.
All right, so we took it from the Twitter account. It says, Turtle Boy says, "Hi, Brian, I have a question." Lucky says, "Okay." Turtle Boy, "And did you plow Fairview on the morning of January 29th, 2022? I'm willing to keep your name out of this as I don't want you dragged into this." Lucky responds, "I'm not answering any questions anymore. I'm sorry if that makes things difficult." And that's Turtle Boy responding to the allegations of threats. But there is a video of Turtle Boy talking about Lucky a few years ago that was posted on X by John Barron. Take a look.
You should fear me, like not fear, not like physical fear. But like I said, the Alberts fear me much more than I fear them. Because I have the ability to severely change their lives. And that goes for you too, Stephen. And that goes for you too, Mr. Lucky. You need to contact me and do the right thing. And you're going to have a conversation with me. Or Brian Albert finds out what you did.
Okay, my guess is that's what Hank Brennan is referencing in the allegations, that there was a threat. John DePietro, so was this a threat? Did Lucky respond to that threat? Did he change his testimony because of this alleged threat?
Benny, you grew up in New Jersey. I mean, if that's not a threat, then I'd like to know what a threat is. You know, anyone, you grew up in New Jersey, whatever. At one time, Providence was the organized crime capital of New England under the patriarchal crime family. Sometimes in many of these situations, the easiest thing to say is, you know, it's the Sergeant Schultz defense. I didn't see anything. I didn't hear anything. You know, it was interesting that Special Prosecutor Hank Brennan went down this path. He also mentioned, Lucky, did you know you were recorded without your permission? He said that he didn't know about that. Massachusetts is a one consent party state, a two consent. So if he did record him, that would be illegal. But there's something odd about this. I believe Lucky when he says he didn't see anything. However, there seems to be this odd dynamic where he really wanted to embellish a little bit, that there'd be nothing wrong if he didn't see anything. Vinnie, if anything, this kind of also strengthens the McCabe's that said when they left they didn't see anything. And by now, when Lucky was there, we actually had snow on the ground because you're not plowing unless there's snow. So my take on this whole thing is I don't think he saw anything. There's nothing wrong with that. I thought Hank Brennan did a pretty good job kind of asking him. He was giving different times of when he was there. But make no mistake about it, there's an odd dynamic of how this came about and now how, you know, the blogger is claiming that he didn't threaten him.
Wayne Dennison, the implication from Hank Brennan is that, Lucky, you on the stand, you are testifying the way you're testifying because of a threat from a blogger on YouTube. Will the jury buy that? Will the jury believe that?
The jury is going to be instructed that the questions of lawyers are not evidence in this case. And the evidence in this case is that Lucky says he wasn't threatened. Unless Mr. Brennan chooses to put in the video you just played, the jury is supposed to disregard the question.
We shall see. But I know the way you lawyers are, Wayne. You guys, yeah, the judge is going to say that, but you get that stuff in there all the time. All right, great news. Wayne and John are going to stay with us. Coming up next, why did Officer Dever change her story?
You saw Brian Higgins and Chief Berkowitz go into the Sally Port together and alone with the SUV for a wildly long time.
That was my recollection at the time.
Karen Reed is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county.
Come at me.
John O'Keefe was killed by that defendant, Karen Reed.
She's the victim of a corrupted investigation that was never about the truth.
Another big day here at the Dedham Courthouse.
Fight on. Nothing's breaking me, Matt.
You'll see it all unfold right here on Court TV.
The Karen Reed murder retrial. Live coverage weekday mornings, 8/7 Central on Court TV.
Miss Dever, do you want to be here today?
I have no relation to this case, so...
I didn't ask you that. I asked you if you want to be here today.
Objection.
I am put on the stand in a murder trial. I don't know why I'm here. I have no connection to this case.
You have no idea why you're here?
You've never talked to me. Nobody on the fence seems to talk to me since prior to the first trial. So I don't have any idea why I'm here.
Perhaps some of the most awkward and uncomfortable testimony of the trial, and that's coming from Boston police officer Kelly Dever, who at the time of John O'Keefe's death was a Canton police officer who was working dispatch after John O'Keefe's body was called in and they started responding. She was on patrol that night, then went back and was working dispatch, so was back at the Canton Police Department. So her testimony is about what was going on in the Canton Police Department. And it's not testimony that was necessary for prosecutors to try to prove their case, but is very relevant to the defense and their theory of the case. So let's take a listen to her testimony. She's called by the defense, even though there's a little bit of friction there. Oh, a whole lot of friction there, because she does not want to be testifying for the defense. Take a look.
Did you tell those law enforcement agents on August 9th, 2023, that you saw Brian Higgins and Chief Berkowitz go into the Sally Port together and alone with the SUV for a wildly long time?
That was my recollection at the time.
So you did say that?
At the time, that is what I recollected.
Okay.
Given factual information, that makes it so I know I did not, no.
So the answer is no.
Correct. Because of the fact I was provided factual information that showed a statement of mine was a false memory, it was not a lie. Therefore, I made it in good faith, and I retracted given information that it could not be accurate. I did not see anything. Factually, I've been provided evidence by a timeline that it is not correct.
Wow. So the significance of her original story was that Higgins and former Chief Berkowitz were in the Sally Port for a wildly long time, and she noticed it. And then she retracted that based upon a timeline that she learned of, saying it was a false memory. And that brings us to the next question in our investigation. Why did Officer Dever change her story? Still with us, Wayne Dennison and John DePietro. John, this was strange. This was awkward. This was uncomfortable. But why? Why is she retracting? Why is she changing that story?
Many people, they misremember things. You know, you've been in the courtroom. You and I were in the courtroom at the same time. You've seen the makeup of that jury. Alan Jackson, make no mistake about it, he's a very talented defense attorney. I think this one got away from him. You know, the way he was kind of badgering her, there's a lot of younger females on this jury, and I think this went over like a lead balloon. It's a legitimate question, but the more tension that was involved, I think it's the biggest gaffe the defense made, because she got to bring in the FBI and even accuse them of wanting to commit perjury. I understand why they maybe wanted to ask it, because she initially said she had been there. Then apparently the FBI, you know, worked out a timeline. She wasn't even at the Cannes police station when they would have been in the Sally Port. I understand what the defense was trying to get. I don't think they got there. And I think as they look back on this, I think it's the biggest blunder they've made.
Wayne Dennison, I want you to take a listen to a little bit more of the testimony. And this is about a meeting that she had with the Boston Police Commissioner. She now works for Boston PD.
Did you have a conversation with anybody in the commissioner's office at Boston Police Department?
Not about anything malicious.
I didn't use the word malicious. Why do you say malicious?
I had a conversation, but it was my department saying, regardless of what I need to say on the stand, they support me.
Did you tell the defense that when you were called up to the commissioner's office, we told you two things? Commissioner Cox told you, number one, the Boston Police Department supports you, and Officer Dever, do the right thing.
So he said my name correctly. He said Dever. And
that's my mistake. Let's see. Like, you want me to repeat the question so I get
So,
right?
Mr. Jackson, let's go ahead and answer, please.
Yes, and he said nothing with the intent of guiding me one way or the other.
What his intent was, madam. I asked you what he said to you. What were his words to you?
That he supports me.
And?
Just wanted me to tell the truth up here.
And his words were, do the right thing, right?
I don't recall.
Wayne Dennison, I'm going to change the question just a little bit for you. And what will the jury think about why Officer Dever changed her story?
Well, I think there's a real possibility that Alan Jackson, in fact, rehabilitated a very difficult moment, because this notion of police cover-up has run its course through this trial. It's the defense's principal defense. And the suggestion is that this witness is now part of the cover-up. She's now a Boston police officer. She was a Canton police officer. And quite frankly, the language that she used in her previous statement, that they had been in the Sally Port behind the vehicle for a wildly long time, is a pretty strong statement for a person who is now misremembering, or purportedly misremembering, the fact that she was not even there.
John, you made a great point about many of the jurors being sort of the same age as Officer Dever, which could impact the way they see all of this. I understand that. But how about in Boston in general? What is the temperature? What is the reputation of the police to the public? Like, is Boston one of those cities? And I've watched a couple of movies like The Departed. Okay, what is the public's attitude about whether or not police will cover things up for one another? That the commish will come down and give orders to make sure this doesn't make us look bad?
I think the climate's changed, Vinnie. You got to remember, it's a female governor with Maura Healey, of a female mayor of Boston, Mayor Wu. And we've seen a lot of men come into the courtroom for police. This is a female police officer. And I understand the intent, but this is also the second, you know, he was pretty rough. And again, I respect Alan Jackson, but he was rough on Katie McLaughlin, who's a first responder. I just think, you know, she doesn't fit the stereotype of what you would think if there's someone that's kind of shady and maybe involved with some element of corruption. So I understand the strategy they were going for. I just don't think it worked out. And this was their witness. But I just feel a lot of the young women on this jury, and as I said, they're younger, maybe they related to a boss they had or someone that was giving them a hard time and they made a mistake and just kept badgering them on it. As I said, I think this got away from them, and if they had to do it all over again, they wouldn't have called or handled it that way.
Wayne, sometimes when a story changes, it highlights the original story even more, makes it more powerful. Would this have been better for the prosecution if the original story was what it was and there was no changing of the story? Because all of a sudden now, that seems to introduce at least the idea of a police cover-up.
Well, the prosecution would have had to put on a witness who previously testified or at least indicated that that Mr. Higgins was wildly behind this vehicle while at the Sally Port. I fully understand why you wouldn't want to put this witness on as the prosecutor. I quite frankly also understand why you would want to put her on as a defense witness. And as much as John relies on the new governor, there is a historic sense that police officers will make sure that they protect their own.
Wayne Dennis and John DePietro, always great to have you on. Thank you so
Good to
much.
Be with you, Vinny.
Up next, what did Sergeant Barros see?
Judge.
I'm Vinnie Politan. We continue our investigation of the death of Boston police officer John O'Keefe, a man who was raising his sister's orphaned children when he was found dead on a fellow police officer's front yard. His girlfriend, Karen Reed, has been charged with his murder. Here's the story. The death of Boston police officer John O'Keefe on a snowy January night in Canton ignited a firestorm of controversy, much of it centered around a cracked tail light. Prosecutors allege that Karen Reed, O'Keefe's girlfriend, struck him with her SUV and left him to die in the front yard of 34 Fairview Road. They point to the broken tail light as crucial evidence, claiming it matches injuries on O'Keefe's body and glass fragments found at the scene. But Karen Reed's defense argues the tail light was broken after the fact by investigators themselves, and that she is being framed to protect others. Supporters of Reed have rallied behind her, insisting the taillight is part of the cover-up. With dueling experts, impassioned crowds, and mounting suspicion on both sides, the broken taillight has become more than just a piece of shattered plastic. It's the symbol of a case cracking open at the seams. The tale of the taillight. It's been about several pieces of evidence in this case, but it always seems to come back to the taillight. Karen Reed's taillight was cracked. The question is, how much cracked was it? Who cracked it? How did the pieces end up on 34 Fairview? The prosecution theory is simple. She struck John O'Keefe, it shattered, and the pieces were there. The defense theory, much different. She partially cracked it when she backed her vehicle into John O'Keefe's. And then when the state police took custody of her SUV, they pulled the pieces out and planted them at 34 Fairview. Those are the two stories. So what did the taillight look like? Well, there's the picture of the taillight, fully cracked, that's been shown to this jury. On the stand, a witness called by the defense, a police officer who works for another town, not for Canton, not for the state police, but for another jurisdiction, Dighton, who was there seizing the SUV from Karen Reed's father's house. He was shown a picture of the fully cracked taillight and was asked to compare that to what the taillight was like when he seized it and handed it over to the state police. Take a listen.
Is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not. That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing. So this area was intact. This is what I saw was missing here.
Okay, so based upon his testimony and his use of that laser pointer, we have put this together. Take a look. This is what he's describing. He's saying that piece that's outlined in blue, that's what was missing. The middle piece he references, he says, was intact. And that brings us to the next question in our investigation. What did Sergeant Barros see? Did he see a fully cracked tail light or a partially cracked tail light? Fully cracked the way the prosecution says or partially cracked the way the defense says? Here to help answer that question, longtime Massachusetts attorney, prosecuted one of the first trials I covered at Court TV in that same courthouse. Richard Grundy is with us. Also joining us, journalist Rebecca Lavoie. She's also the host of the Crime Writers On podcast. Make sure you download it right after the show. Not before we finish, but right after the show. Please download that. Okay. What do you think of that testimony, Rebecca? That testimony from the Dighton sergeant saying the picture that is in evidence of the fully cracked taillight is not what he saw.
Well, I think it's important to note this isn't the first time we've heard him testify as such. We heard him say the same thing in the first trial in sort of an unexpected turn. When he was on the stand as a prosecution witness, he said it was just cracked. It wasn't fully out of its casing, so to speak. So I think that after seeing Kelly Dever on the stand, being reticent to be candid, after seeing Buchanan on the stand, after seeing cops from Canton be on the stand, I think that it was clear to me that this particular police officer had a story to tell. He's been looking forward to telling it, anxious to tell it because he believes it's the truth.
Okay, Rick, there's always cross-examination. Let's take a look at Hank Brennan on the cross-examination of Sergeant Barros, referencing a different image that this jury has seen.
You would agree that your memory has changed since last time you testified in this courthouse?
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dighton on January 29, 2022?
Objection.
I'm going to allow it. It was opened up. It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Okay, so they show him a different image. We've put him some of these images side by side because he also referenced, so what you're looking at on the right-hand side, Rick Grundy, is the tow truck image of that right tail light at the time that he seized it. And he said, yeah, that's what it looked like. And that is the side of the vehicle. We've zoomed in on that. On the left-hand side is a zoom in on the right tail light of Karen Reed's vehicle, 8:23 in the morning, following the discovery of John O'Keefe's body. Prosecutors love the image on the left. The defense loves the image on the right. Sergeant Barros says both of them are consistent with what he saw. So let me ask you, what did Sergeant Barros see? A fully cracked tail light or a partially cracked tail light?
So I think what Officer Barros saw is what you just showed me, Vinny, and that is a very blurry picture with some red and some yellow and some white in it. And that's on my right, and to my left was a picture that was a little more clarity, but basically looked like some snow on a surface that if you told me it was a car, I'd believe you. So it really is, in a situation like this, it's his credibility, because I don't think those pictures are going to move a juror in one direction or the other all that much. And also take into consideration, jurors at this point in time have probably started leaning to one side or other. So it could be that kind of evidence, just looking at the pictures, that, well, you know, I'm going to use that to lean in the direction I'm already going. So it really comes down to Barros. You know, I have to supplant my opinion to him. And if he's that strong of a witness and he comes across to me as a juror that way, maybe I do so.
Let's put that split up again. Rebecca, as we look at the left side versus the right side, Sergeant Barros is saying, yeah, that's what I saw. Do you see these two as being consistent? Do you see them as being different? What did he see? Did he see a partially broken tail light or a fully broken tail light?
Well, Vinny, if you look at the picture that the Commonwealth keeps putting up of the taillight in the Canton Sally Port, it doesn't look like either one of these pictures. So I could just kind of leave it there. That being said, as we were just...
Well, let me interrupt you for a second, Rebecca. I hate doing it. Your first time on the show, I'm interrupting you. I apologize.
That's fine.
But you bring a great point up. So if the picture that is shown from the Sally Port is not consistent with either one of these, then what you're telling me is that there may have been some manipulation of the tail light.
All I know is that Officer Barros does not seem to have much incentive to come into this courtroom, put his reputation on the line, put his, being on Massachusetts witness lists in the future on the line. He is telling us what he believes he saw. And, it's not that inconsistent, actually, with the police report at the time, which says the right passenger side taillight was shattered and a large red piece of plastic was missing. So that's what he's describing. That's also what's in the police report at the time. And I don't think I would describe the Sally Port picture as one red piece of plastic missing.
Rick, we have about 30 seconds here. I hear you, but do you think in a case like this that in that jury room, the jury is going to have a debate about fully broken versus partially broken? Or do they move away from that and focus in other places? Because so many members of the public have focused on this issue.
Yeah, I think it may garner more attention from a jury, especially, if you've got the split and you're laying out your different arguments. I think when they get to this particular piece of evidence, it may well bring about some pretty heated debate, because it could present strong evidence for either side. The way the Commonwealth has presented the case this time, which they had to, was to present a theory that's consistent with Officer O'Keefe getting those injuries that he had. It's now a real linchpin that, that light busting up is what created these injuries on his arm. On the other side, it's a real linchpin to a conspiracy, because, that could still put her in jeopardy. He still got hit. It just didn't break as much as possible. And somebody came along and said, let's make it look a little bit better. So, yeah, I think either side could get a good fight out of it.
Still to come, did Chloe the dog do it?
What is your opinion and conclusion concerning those injuries?
Those wounds were inflicted as the result of a dog attack.
Lori Daybell, doomsday cult mom, convicted killer, and now defendant in yet another high-profile trial.
She didn't really care who she hurt.
This time for the attempted murder of a former family member.
Just makes you sad.
And again, she's representing herself.
What about the same problem?
Are you done? Or are you just going to keep
Will this be the final chapter in the saga
of the Doomsday Cult Mom? The Cult Mom Conspiracy Trial. Live coverage weekday mornings, only on Court TV.
Based on your review of all the materials that you had described and your experience that you had described, without stating it, were you able to come to any conclusions or opinions about the source and nature of the injuries that you see depicted on that exhibit?
Yes.
And what is your opinion and conclusion concerning those injuries?
Those wounds were inflicted as the result of a dog attack.
Dr. Marie Russell, the dog bite expert for the defense, giving her opinion. But what is the basis of her opinion? I think that's really significant here. Not just the conclusion, but how she came to that conclusion that the injuries on John O'Keefe's forearm were from a dog attack. Take a listen.
There are multiple groupings of wounds right here. Here's one on the what I'll consider the upper arm, which is above the elbow. Here's another grouping. Here's an interesting, complex grouping at the elbow. These are all at the posterior surface of the arm. And there's another grouping down here on the forearm. These multiple groupings are patterns. And they are, in my opinion, were inflicted by the teeth and claws of a dog. The teeth made these abrasions in this direction, from here down to here. I believe that this hole was made by a canine tooth, and with the tooth going into the shirt, reaching the skin, and then coming out of the shirt, pulling out some fabric with it.
So this testimony, significant for the defense. It's part of their case, and it brings us to the next question in our investigation. Did Chloe the dog do it? Did Chloe the dog inflict those injuries on John O'Keefe, which would then eliminate a big part of the prosecution theory on how John O'Keefe died, which is being struck by the vehicle? All right, helping us with our investigation, longtime Massachusetts attorney Rick Grundy, along with journalist Rebecca Lavoie, the host of Crime Writers On podcast. Okay, Rick, so did Chloe the dog do it?
Chloe's innocent. She's going to be found not guilty. I don't know about Karen, but Chloe's going to go free, wherever she may be. In my experience, these are not, when a dog's biting, it's not using its claws. When it's using its claws, it's not biting. So to get this kind, and it seizes on a spot. What a dog does when it is attacked, it seizes on a piece. It doesn't bounce. I'm gonna get the bicep. Let me get a little elbow now, and now I'm getting a little forearm. So based on my experience, I've never bought into that this is a dog attack. I know there was theory about it was animals after he was left out there. I don't know. But I think with respect to Dr. Russell, the cross-examination shows that she is completely inexperienced as far as being a forensic scientist in this. She has treated dog wounds, and obviously that's going to be more experience than a lot of us have. But I think she's been kind of exposed as not an expert or only a self-professed expert. I think she actually may have been more help as a medical examiner in the opinions that she gave in that area for them. But I think you take a step back for the prosecution and look at this and open the window, and you're in a position to say, you've made this a cornerstone of your defense. And since improperly, the jury is clearly aware now that there's been a first trial, which is constantly referred to, which is wrong, but they know that, and you can put before them in your closing, you came into this trial, the first one, without a witness for the cornerstone, one of the cornerstones of your defense. And this woman called you out of the blue.
Yeah.
and say, hey, I can come in.
And they did find out. They found out about that. Let's take a listen to a little piece of the cross, Rebecca.
Would you agree that the superficial abrasions on Mr. O'Keefe's arm had no punctures?
I agree.
Would you agree that the abrasions, the superficial abrasions on Mr. O'Keefe's arm had no depth?
No measurable depth, yes.
Okay, no punctures, no measurable depth. Rebecca, does that undermine the theory that this was a dog attack?
No. What you have here is an incredibly experienced physician and forensic pathologist. She's been working in emergency rooms for 3 decades. The dog bite that Richard just described, the holding and latching, that is a trained police dog or trained military dog style bite. A domestic dog, which I believe some members of the jury may have had experience with, or perhaps they've gone to a dog park and encountered a dog that, perhaps didn't enjoy being with people or other dogs. That is what it looks like. All you need to do is do a Google image search of dog attack arm, and you'll see John O'Keefe's arm, of course, will come up in the images, but so will dozens and dozens of other people who have been encountered a perhaps not well-trained dog or a dog owned by an aggressive person or a dog with other behavioral issues, and that is what their arm looks like. And I'm stunned at the idea that Dr. Marie Russell would be considered an inexperienced witness. I have been watching trials since the early 2000s. I've never seen a more specifically qualified witness, I think, in terms of a medical opinion than her for this particular thing. And where's the prosecution's medical expert saying that they are caused by that those wounds are caused by plastic shards of taillight? There was no medical expert who said that. So I don't even see this as being close here.
Rick, we have about 30 seconds left here. I'll give you the final word on this. And one thing I want you to address is, will a jury go into the jury room and look at that and, whether there's experts on both sides, cancel them out and just say, this is what it looks like to me?
Yeah, I think that's a very likely possibility. Again, this is just one of those things which there are dozens of in this case, which it can be argued convincingly in either manner. The little clip that you showed kind of showed the witness, Dr. Russell, kind of coming out on both ends. No puncture wounds, again, in a actual dog bite. That's going to be highly unusual. They don't get their canines in there and create puncture wounds. But the clip you showed before, she's talking about, oh, I think this is a puncture. It's through the clothes, into the arm, etc. So again, I don't think there'll be any kind of unanimous opinion that's based on what Dr. Russell put forth.
Rick Grundy, always great to catch up with you. Rebecca Lavoie, great to have you on the show. Crime Writers On is the podcast. All right, folks, reasonable doubt means different things for different jurors. And sometimes it manifests itself in one piece of evidence a particular juror is just not comfortable with. But in a criminal trial, the only thing that prosecutors have to prove beyond a reasonable doubt are the elements of the crimes that have been charged. Now, that sounds kind of simple, right? But many times the jury has too many unanswered questions about those crimes. I'm Vinnie Politan. We'll keep digging for answers as the investigation continues.